So Peter, let me bring you into the conversation if I could. So I think as several of us mentioned, your metamorphosis of authorship paper is widely recognized as one of the early critical legal studies influenced interventions in the scholarship. It has a internal critique of the concept of authorship that to me is very Felix Cohen influenced. It takes a concept that is treated as a unitary idea that can determine the sub rules within the copyright space, and shows it to be contested, and shows the result of that contest to be outcomes that you criticize as being unjust. So it's the combination of the internal and external critique. But that's how I read the piece. What did you intend with the piece? I mean, what was going on with you at those times? What was your experience with critical theory? Were you trying to do it? Were you just influenced by it? What's the purpose and intent and impact of doing critical work within this space?
Especially as Duncan said in his very complimentary mention of the paper earlier, without self-identifying as doing so. And the reason for that,
I don't know if I agree with that. There's a hefty footnote that cites all
oh no, I think I know exactly what he means, and I can explain it too, because the truth is that I got started a little too early to be a kind of, I graduated law school in '71, to be a kind of fully invested participant in the CLS movement. So I followed it, but I was more of a lurker, really, than anything else, an admiring lurker. And in the late '80s, when I wrote that paper, I was simply too lacking in confidence, in effect, to self-identify prominently in that way. But I think there is no question that there were at least three, what I take to be, and others may disagree, central insights of critical legal studies that I was very impressed by. And one was, of course, its emphasis on the indispensable insights of legal realism, including the commitment to anti-formalism and a focus on how doctrine reflects social economic ordering. That was an absolutely critical thing that CLS was doing. Another was bringing into sort of focus, at least for me, I know for others, the ways in which relevant schools of late modernist legal theory, discourse analysis and structuralism, and certainly deconstruction, could be applied to the exploration of legal texts. And then there was also something that impressed me as a consumer now of this material, and that was a commitment to the importance of utopian reimagination as part of the critical project. And so all of this was meaningful to me, but not necessarily operational for me. I'd, of course, been impressed by the early demonstrations, especially by Duncan and also by others, of how these techniques can be widely applied in a variety of discourse settings. But I didn't feel a high level of confidence in my own ability to do. I had 7 years of higher education, 4 years in an English department and 3 years in law school, which were completely innocent of any mention of any kind of contemporary theory. It was the most descriptive, atheoretical, supposedly high quality higher education that one could possibly have sought. And if I hadn't been a film enthusiast who was sort of steeped in the work of the new wave critics and their American followers, work that was, of course, as it turns out, somewhat ironically based on the affirmative politics of authorship, I would have been entirely clueless about the connection between theory and any kind of academic enterprise. So a few years on, as I was recovering from that educational experience as a litigator, I found myself, for reasons that need not be mentioned, thrust sideways again back into a law school environment with all the attendant expectations of publication and so on and so forth. And I was pretty much at sea. I didn't know what to do. So I did the obvious thing. And that is that I wrote a long sort of, descriptive, prescriptive tenure piece. And that was that. And then I was stuck again. I knew I had to keep writing. I conceived of another vast prescriptive project, and I realized that it was just stultifying, and I never wanted to do it again. And I didn't have to, as it turned out. So I began looking around for something else, a way out of the wheel in the squirrel cage, so to speak. And where did I look? Well, you couldn't find much in current intellectual property scholarship. As Karis mentioned, there were, of course, or had been, of course, Felix Cohen's trailblazing efforts to kind of break down trademark law. But copyright scholarship was really dominated by doctrinal description and policy prescription, the latter sometimes incorporating a kind of smattering of vulgar microeconomic analysis. There were a few honorable exceptions. There was the work of my teacher, Benjamin Kaplan, who is sort of avant la lettre. And there was, of course, the early work of Gary Francione before he went on to do more important things. But I couldn't find much internal to copyright scholarship that I could work on or work from. I could and probably should have had the confidence to go back to those central insights of CLS as I understood them and tried to summarize them earlier. I think implicitly I did to some extent, but that isn't actually what I did at all. What I did was to go outside legal scholarship and see whether in other domains there were academics who had different takes, in effect, different perspectives, different bodies of evidence that they were bringing to bear on, central questions of copyright, of which one most obviously, unavoidably, I would even say preeminently, was this issue of the nature of authorship. And I was lucky because I discovered a wonderful sort of body of sort of new materialist work in the field of book history, especially the work of my, as it turned out afterwards, longtime colleague and collaborator, Martha Woodmansee. And there was also this kind of Barthian Foucauldian discourse analysis around authorship that the book historians had picked up on and that was also available to me. And those were really my direct channels into the work. The influences of CLS should get none of the blame for its inadequacies, which have been pointed out very poignantly to me by a lot of people over a long time. But I do think that in actually performing that work, and then the related work or work related to it that followed, the work that developed this notion, the critique of authorship in in intellectual property law, CLS should get a lot of credit, if not for the work, or then at least for helping to release me from an intellectual life to ordinary. So I think I'll stop there and see where the discussion takes us. I would just like to say, going back to what Karis and Severine and Duncan were talking about with respect to the licenses, that I agree that the question of how to behave in this new world of open licensing, and the choice between revising the licenses themselves and supplementing them with other materials, I think it's just an enormously important question. For the last couple of years, I've been immersed in work on the application of copyright law to open educational resources, something Karis knows well about because she's been helping us very substantially on the Canadian dimension of that project. And it's absolutely clear to me that the liberatory potential of open licensing remains extremely strong in some use contexts, of which clearly education is one. And so we're at a crux in this respect. And I just can't compliment Severine's work enough, both on its timeliness and of course on its quality and on its importance.
Thank you all. This has been really rich, and I think especially for all the budding scholars, the tales of kind of how to get into a project and where to find different sources of animation and insight is really wonderful to hear.